This Honorable Court of Criminal Appeals is now in session.
Thank you. This is the March term of the Court of Criminal Appeals in Western Tennessee. On the court's panel today, to my right will be Judge Tim Easter from Williamson County. To my left, Judge Ross Dyer from Shelby County. I am Kerwood Witt, and I live in Monroe County. Call our case, please.
Darius Jones versus State of Tennessee.
Arguments are 20 minutes per side. If counsel for the appellant wants to reserve a portion of that 20 minutes, please make that announcement at the beginning of argument, and you may proceed.
Good afternoon. My name is David Mays from the Shelby County Bar. On behalf of the appellant Darius Jones, I would like to reserve 8 minutes for rebuttal.
How much, sir?
8 minutes.
All right.
May it please the court. This is a difficult case with difficult facts. However, even difficult cases with difficult facts require effective representation. A lawyer's duty to represent his clients, investigate a case, review the discovery, meet with the client. If the client decides to testify, prepare that client and not go into the case with an idea of utter defeat, but to put on a viable defense. In this case, first off, there was a dispute between the appellant and the state how the gun went off. The state's theory was this was an execution-style shooting at close range by Mr. Jones. Mr. Jones maintained that it was an accidental discharge. At the scene, the photos indicate that the victim, the deceased's hand was preserved and swabbed with gunshot residue for gunshot residue. However, that no analysis was ever done on that gunshot residue. Trial counsel had the ability to request funds for an expert to analyze that and give an opinion on that. However, when I represented the appellant at the post-conviction hearing, I motioned for those same funds and was denied. Ultimately, what the court has now is a bunch of speculative, what would it have shown? And ultimately, what it would have shown may have absolutely been exculpatory. However, without the ability to test that gunshot residue, without the funds from the state to do that, we'll never know. And so ultimately, the post-conviction court said, if you don't have any evidence, we can't hold it up. But the state was in possession of that evidence. And while there's some testimony about the materiality of the gunshot residue testing, that's all speculative. And we'll never know. This court will never know. The jury will never get to decide. Mr. Jones won't have a fair trial without the gunshot residue testing done on the hands, a critical piece of evidence on whether or not perhaps her hand was on the gun when the gun went off, and which would support Mr. Jones' testimony, the appellant's testimony, and a defense theory on the shooting itself. Next, and since the case was charged as first-degree murder and felony murder, the next most critical piece, assuming a crime was at the end, is the kidnapping. And at the post-conviction hearing and in the trial testimony, I asked trial counsel, what is your defense? He has he says there's no viable defense. There's nothing in the record arguing, explaining to the jury why this wasn't a kidnapping. It was and while he was effective in his argument against first-degree murder, as the result came back second-degree murder, it's completely ineffective when it comes to the kidnapping charge, which when you look at the sentence, the kidnapping charge is the one wins felony murder. And felony murder is ultimately what overtakes the second-degree murder verdict by the jury. Without any defense put on, explaining why this wasn't a kidnapping, explaining that this is our theory, the jury was just led straight down the state's theory. Now, some other evidence that trial counsel had available was, number one, a news article. And that news article, according to the appellant, was never turned over to him. But in the possession of trial counsel, who, after multiple requests, even a subpoena that wasn't responded to, we have what we think is his trial file. But I'd also point the court to the response of where his file actually is and what I did and to try to get that file and how we had to piecemeal it together. Nevertheless, inside what we did get was a news article. And in that news article, there was eyewitnesses that conflicted with what the witnesses testified to at trial. That witness was never asked to be searched, looked after, and without that, then all we have is the state's witnesses that they bring on. Similarly, when it comes to kidnapping, the actual tone and the conversation that's going on in that house would be absolutely critical. And that's where the 911 tapes that were requested by the prosecutor, but never retrieved, and now lost, is missing a critical piece of evidence for anyone who needs to judge this case as to what was going on in that house. Could hear the live audio talking between the appellant and the 911 tapes. Ultimately, Mr. Ganguly is a fantastic lawyer, and he pointed out in the trial transcript how many cases he was representing at that time and how many favorable verdicts he had at that time. But also, in doing so, he points out how focused he was on other cases and not focused on this case. Ultimately, the trial counsel, at best, based off his bill and his testimony, met with Darius Jones a couple of times, but it's uncontroverted that he never prepared him for trial, because in Mr. Ganguly's words, it was not productive to talk with his client. His client had, in Mr. Ganguly's description, anger issues, and which created a divide between him and his ability to prepare his client. So ultimately, what we have is a client who never gets prepared, has no background, and steps up to the plate in the World Series with his life on the line without any preparation. Absolute setup for failure. And how is Mr. Jones, the appellant, supposed to get a fair trial without any preparation? Now, the state's response is, well, he should have known all of this stuff, and there's nothing material in his testimony that would have changed with preparation. Who's to say, right? That all we see is an unprepared testimony from the appellant. No time spent before, no preparation, and without that, collectively, the appellant can't get a fair trial. Ultimately, the bar of representation should be high for a criminal defendant. Regardless the facts of the case, they need effective representation, and that representation a lawyer can't go in with a presumption of my client's guilty. There's nothing I can do for him. And it appears from the testimony of Mr. Ganguly and what was done in relation to the kidnapping and preparing his client, it just appears that this is a case that he dropped the ball on. Ultimately, without gunshot residue testing and results, without the witnesses of the kidnapping, without an argument of the kidnapping, without a prepared client, and without the 911 tapes, Mr. Jones is unable to get a fair trial, and due to the ineffectiveness of his counsel, and we would ask that the case be remanded to the trial court.
Ms. Decker?
Thank you. May it please the court, Catherine Decker representing the state of Tennessee. We've touched on some of the facts of the offenses, but I think it would be beneficial to just briefly put these claims in the context of the offenses. We have multiple witnesses that established both the murder and the kidnapping of the murder victim and of her two children. The day of the murder, the petitioner and his girlfriend, who's the victim, were arguing about money. At one point, she left their house and got into a friend's car. The petitioner pulled the victim out of the car, and when she tried to get away from him, he pointed a gun at her and dragged her back into the house. That's the kidnapping portion. We have 3 witnesses who testified about that. The victim's mother lived with them in the house. She heard the victim call from a bedroom. When the mom went into that bedroom, she saw that the petitioner had the victim in a headlock and was holding a gun by his leg and swearing at her. The mom stepped between them. The petitioner released the victim from the headlock and said to her, "You think I won't kill you?" He demanded the money. She said, "Why?" And then he reached around the mother and shot the victim in the head, execution style. At the time of the murder, the victim's 2 toddler children were standing in the doorway. The mom ran out of the house, but the toddlers were kept inside the house for the hour or so when the police had surrounded the house before the petitioner surrendered. The petitioner testified for 91 pages at his trial, claiming it was an accident. He was charged with premeditated murder, kidnapping of the victim, and kidnapping of her 2 children. Trial counsel, despite all of that clear evidence, was able to obtain lesser included offense on the most significant charge, which is premeditated murder. He got a 2nd-degree offense, and he was also able to obtain a life sentence instead of a life without parole. So turning to the first issue, which is ineffective assistance of trial counsel for failing to adequately communicate with the petitioner and adequately prepare him for trial. In his brief, petitioner raises a lot of iterations of this and has touched on a few of these, in his argument. I'll try to refer to those that he's raised in his argument and then see if you have any questions about the other iterations that he's raised in his brief. So concerning the amount of time that the counsel spend with petitioner, I believe defense counsel has restated his claim that he makes in his brief that defense counsel only spent a few hours with him, but the post-conviction court specifically accredited trial counsel's testimony over the petitioner's false claim. And trial counsel's testimony was that he met with him on multiple occasions. He met with him from 4 to 6 times for 45 minutes to an hour each time. He discussed trial strategy with him. And also that he had an investigator, Rachel Geiser, who met with the petitioner many times. And as I said, the PC counsel has expressly accredited that testimony over the petitioner's contradictory PC testimony. In any case, concerning any kind of prejudice, neither in his brief nor on oral argument does petitioner specify any particular way in which any additional communication or any different type of communication would have benefited him in any possible way. He makes gross generalizations, but it's incumbent on him in an ineffective assistance of trial counsel claim to specify exactly what the prejudice would have been. And he fails to do that. Concerning a claim that petitioner was unprepared to testify, in his brief, the petitioner asserts that he was unprepared to testify because he had not reviewed witness statements, and generally that he had not received discovery. And I think he reiterates that in his oral argument. But in his PC testimony, the petitioner himself acknowledged that prior to trial, he did receive those witness statements. And as to discovery in general, the PC court, who was the trial court as well, found that it was, in his word, it's the court's words, absolutely an impossibility that the petitioner did not receive discovery, because it has been that court's routine procedure for the past 13 years, the court said, never to set a case for trial unless it has specifically inquired as of the defendant, did you receive all your discovery? And he said he would have done that in this case. So he discredited any claim, any assertion by the petitioner that he had not received discovery. And those findings go to whether the petitioner approached his trial completely unprepared with no background whatsoever. That's just, according to the PC court, categorically untrue. Another claim that was raised in the brief and in oral argument is that petitioner was unprepared to testify because he hadn't reviewed photographs of the scene, but as the PC court ruled, there's no evidence that those photographs would have changed any aspect of the case. They just didn't hinge on whether this was an accident or intentional. They just had no relevance to the charged issues. So whether petitioner was able to see the photographs before trial or for the first time in trial wasn't prejudicial. And in fact, petitioner has not identified any way in which he was prejudiced by when he saw the photographs. I'm not going to touch on the petitioner's claim that he felt forced to testify, because the PC court went to great lengths to discredit the petitioner's claim at the PC hearing that he felt forced to testify. And that was based on a very, very particularized moment hearing. But concerning the claim that petitioner was unprepared to testify because counsel hadn't met with him sufficiently, in his brief, the petitioner said he was shocked at the misunderstanding and mischaracterizations of his own records and fell apart during cross-examination. Petitioner does not cite to one line of his cross-examination. He doesn't cite to any way in which he fell apart. I have read every word of his testimony, the 91 pages. There's no evidence that he fell apart completely. He told his story, and he stuck to his story during cross-examination. But in any case, it's incumbent on the petitioner at this point to establish first of all, to point to what evidence, to what testimony is referring to, and then to point to some way in which a different or better preparation would have altered that testimony and then altered the outcome of his trial. Unless this court has any other questions about issue number 1, I will turn to issue number 2, which is the claim that the petitioner's counsel is ineffective for obtaining the audio tape of his 911 call. And in his brief, the claim is also ineffective for failing to request missing evidence jury instruction, a Ferguson instruction. I'll just briefly respond to the claim that he was ineffective for failing to request the audio tape. he was appointed, as was established at the PC hearing, Memphis Police Department routinely destroys those tapes after 18 months. And so Mr. Ganguly was appointed 17 months and 16 days after the offense. And even in his brief, the petitioner concedes that it would have been unreasonable to expect him within those 14 days to have requested the 911 tape. But so that goes to the deficiency prong. But furthermore, the PC court has addressed the prejudice prong as well, and that is that there's no evidence that had Mr. Ganguly quickly requested that and obtained a 911 tape, that it would have made any difference to the outcome of this trial. In the PC hearing, and then also in his brief, the petitioner seems to argue that the 911 tape would have somehow benefited him in his claim of kidnapping of the children, because he claims it would have shown that he said, I'm not going to hurt the children, or something about how he was treating the children. But he was not charged with kidnapping the children based on any sort of maltreatment of the children. He was charged with kidnapping for confining them with a deadly weapon. And the 911 tape would have had no relevance whatsoever to that kidnapping charge as it was charged. We have some other speculation about whether it would have reflected his shock or what his state of mind is, but we don't know that. The petitioner could have called to the PC hearing the cousin or the grandmother who the petitioner also spoke with at the time, but he didn't. So we don't have the evidence of his state of mind. And in any case, as I've mentioned in my brief, the petitioner is just as likely to have been shocked at having realized that he intentionally killed someone and to see the aftermath of that as he would have been shocked for accidentally killing someone. But what I'd like to focus on is the fact that is this new claim raised for the first time on appeal that he was ineffective for failing to request a Ferguson missing jury instruction. That has been waived because on appeal is the first time we have heard of that claim. So make no mistake about that. It was very clear in the PC petition, this is the wording of the claim. Trial counsel failed to properly communicate with petitioner regarding the 911 audio tape and failed to secure those tapes within the normal retention time. That is the only claim in the PC petitions regarding that claim. At the closing argument.
Counsel?
Yes.
So let me make sure I understand your waiver argument. Not only did he not plead it in his PC petition, but then did he argue it at the PC hearing?
No, he didn't. And I'll tell you what he argued. This is his closing argument. It's never been mentioned before by the petitioner before his brief. This is his closing argument. Second, we feel Mr. Ganguly was ineffective because he didn't seek the 911 audio tapes. We believe a defense counsel has a duty to investigate defenses. And in this case, Mr. Ganguly had the ability, while there was a short period of time in between his appointment and the 18-month window, he never even tried. It never even crossed his mind, he said, that wouldn't be helpful. That's his argument. The state's argument was, I guess counsel is somehow suggesting that Mr. Ganguly should work some sort of magic and produce a tape that didn't exist anymore. So both of those arguments concerned his failure to request a tape. Then in the PC hearing, the oral findings by the trial court was clear that the trial court considered the claim simply to be a failure to request, because this is how the court phrased the claim. Petitioner alleged that Mr. Ganguly was ineffective for failing to subpoena the 911 audio tape. There's absolutely nothing about a jury instruction or what it was failing to subpoena, failing to request. And that's on volume 4, pages 111 to 112. In the PC order, the court again, when it lists the 5 claims, does not list anything about failing to request a jury instruction. And this is where I think that the petitioner is has thought of the Ferguson issue to raise on appeal is in a section in the written order entitled "Failure to Introduce Exculpatory Evidence." The PC court then cites to Ferguson and talks about a Ferguson analysis. But it's clear that the court still views the claim as failure to request, because it's more like failure to request and introduce the exculpatory evidence. But this was not a claim that the petitioner ever raised. Trial counsel was not asked about it. The state did not get to respond to it. This was not a claim previously raised in the PC hearing. And so for that reason, it's waived. Now, if the court has any question about whether it's waived, I can address the merits, or I could just briefly say that, to obtain a Ferguson instruction, there are hurdles, and some of the hurdles are: it has to be exculpatory, it has to be negligent. You look at this other sufficiency of the other evidence to prove the guilt, and if you look at those hurdles, the petitioner has not even addressed those hurdles in his brief, but the counsel is not deficient for failing to request a Ferguson instruction because he can't surmount those hurdles. He wouldn't have obtained a Ferguson instruction for that reason. And in fact, some of the findings that the PC court made, which are that this 911 tape is completely not relevant to any issue, would have foreclosed any Ferguson instruction in any case. But I could delve into those hurdles more if you'd like, but I really think that this issue should be disposed of because it was waived. Counsel has not addressed the 404B issue, and I'll just rely on my brief because this was clearly 404B evidence of prior acts of violence was clearly sought to be admitted to rebut accident and to show intent of prior relationship. It was admitted for that reason, and it was rightly admitted, and it would not have been a viable claim on appeal. And so appellate counsel was not ineffective for raising what would not have been a meritorious claim. Just let me consult my notes for 1 second, please. Just also briefly on the gunshot, having the gunshot swabs analyzed and failing to call Mr. Clark as a witness, those are easily disposed of because Black requires the petitioner to have brought that evidence before the PC court. And because he didn't do so, he can't prevail on those claims. So if this court doesn't have any questions, I will just ask this court to affirm the decision of the PC court.
All right, thank you. Rebuttal, Mr. Mays.
You're muted, Mr. Mays.
Yeah, y'all will have to, I apologize for my screen. My computer didn't work with Zoom for the first time ever, 8 minutes before we started. Luckily, the iPhone works, but the state did a good job on reciting the facts of the state's theory, right? And when you look at this case through the lens of the state's theory, the facts are difficult. However, when we rely on the multiple witnesses of dragging the deceased into the house, that overlooks the other witness that gave a statement to the newspaper who's completely unbiased, standby neighbor, right? The witnesses that we have are friends and family of the deceased. And in a closing argument, an attorney who's addressing the kidnapping might say, we can't believe these witnesses because they're biased, or whatever argument they want to make. And any argument. But if you look through the closing argument of Mr. Ganguly, he never addresses it at all. And so while, yes, he was effective in the first-degree murder charge down to second degree, he was completely ineffective because he never even addressed the kidnapping charge. No argument against it, no mention about it, no explanation of the law, no argument of the facts, no overlooking a potential witness that conflicts, because the neutral witness is giving a statement to the police the day after it happens that conflicts with what all these multiple witnesses related to the victim testified. That would be a defense, and that would allow the jury to decide who to believe and if there was beyond a reasonable doubt. Plus, what about the inconsistencies in those testimonies? Arguing inconsistencies, anything. There's got to be something. And in this case, when you ask Mr. Ganguly, what was your theory of defense? Crickets. There is no theory of defense, right? He went into that, he ended that trial, and still to this day in the PC hearing has no defense, nothing to even come up with, nothing to say to the jury. Next, the state points out about how it was the mother and the victim and the appellant all in a struggle when the shot went off. And ultimately it comes down to the testimony of the mother versus the testimony of the appellant. But what our claim is that with gunshot residue present on the victim's hand, then there's a viable argument to say this is an accidental discharge over the struggle of a gun. And while the state says you can't bring that because you didn't bring that, well, that's my exact point. I asked the court, I said, let me have a gunshot residue expert. Mr. Ganguly had that at his disposal, and it wasn't at my disposal. The appellant was unable and tried to scrounge the money up and hire the gunshot residue expert himself. Was unable to. We motioned the court, and that was denied. And so ultimately what this court has to rely on is the same speculation that is used against me. Oh, it's purely speculative. Well, it's speculative both ways because we don't have the actual testing. We don't have testimony from both sides. Also, the state talked about the evidence and how the trial court gives, the post-conviction court gives deference to the testimony of the trial counsel about the evidence. Listen to his testimony. He admits that the pictures were never given to the appellant at any time. And what is material in those is a handwritten note, which the handwritten note is almost could be seen as a confession or a recitation of what happened. And you won't find that note anywhere else in the evidence. It's only in the pictures. So when you have a statement by the defendant that's hidden in the pictures, obviously the defendant must see his own statement that he wrote prior to going into trial. And we don't know what we don't know as far as what he said and versus a prepared client versus an unprepared client. I just know as a lawyer, I would never put a client on the stand subject to a professional cross-examination without 1 minute of preparation. And that's Mr. Ganguly's testimony. Mr. Ganguly's testimony, while his bail and his testimony might be 4 to 6 hours, 1 to 2 hours, it doesn't matter. He said at some point he stopped talking to Mr. Jones because he didn't think it was futile. Well, as a lawyer, I think it's very, very important that you talk to your witnesses before you put them on stand, particularly if it's someone's being charged with first-degree murder and kidnapping who's never testified before and is about to go on stand for the first time. Again, I think about even putting me at a T-ball game without some preparation. I would probably strike out, much less putting someone in the World Series for the first time without any preparation. It's Mr. Ganguly's testimony that the pictures were never given, that he didn't feel like talking to was helpful to talk to Mr. Jones. Ultimately, the state does a good job. They've done this before. They pick me apart on all these small details. And I'm sorry, I might not be the best lawyer out there, but when there's smoke, there's fire. And when I look at this And I think about having a fair trial. It doesn't seem like a fair trial to me, especially when you add all of these things cumulatively up. As far as the 404B goes, we asked the Court of Appeals consider that, right? That was an issue that was important to the trial counsel. It was viable to the trial counsel because it was in the motion for a new trial. However, the appellate counsel just didn't put that in front of the Court of Appeals for the Court of Appeals to review. The trial court denied the motion for new trial on that basis. So now the post-conviction court, who's the same person, their opinion on it, it should be reviewed by the Court of Appeals. As to a waiver argument, typically there's going to be some generalized language in there that the ineffective counsel didn't file all appropriate motions. And while I may have not specified Ferguson, certainly there's enough language that if this court wants to review it, it's not considered waived. And also as these things, as we go through the hearing, as we go through the appeal process, if there's issues that the court finds necessary, there's certainly pleadings that the court could rely on. Also, when the state relies on the fact that Mr. Jones he acknowledged having all of his evidence. You don't know what you don't know, right? So if he didn't know there was pictures before the trial, did you get all your evidence? Well, he doesn't know it was there. Ultimately, an accumulative effect on all of these issues, particularly the gunshot residue, testing the 911 tapes. We ask this case, respectfully ask this court to review this case and remand it to the trial court.
All right, thank you. That concludes the argument in this case. The court thanks counsel for presenting your arguments today, and we will be in recess.
Thank you, Your Honors.
Thank you.
This court is now in recess.